Okay, Mr. Mitchum is back in and is ready to make a presentation.
Okay. Hi, I'm calling in via phone, so excuse my quality if it's too bad. But so this is Joshua Mitchum, ECD staff, and I'm giving the read file report. Special exception 930 was filed on May 17th, 2022 by Vanessa Oti to operate an animal boarding facility at the existing Paw Perfect Dog Daycare business located at 595 Main Street, Laurel, Maryland 20707. Under date of May 17th, 2022, a cover letter, floor plan, and justification letter asking for comments were emailed to the following agencies: Prince George's County Health Department. No agencies had comments on the proposed application. Under date of May 17th, 2022, a memorandum asking for comments was sent to the following city departments: City of Laurel Police Department, Department of Parks and Recreation, Department of the Fire Marshal and Permit Services, and the Department of Public Works. The following comments were received. DPW, according to the application, all the improvements are on site and in private right of way. No city street shall be impacted. If any utility cuts will be performed on a city street, the restoration work must follow the city standards that require the permanent patches in the cut area with a 2-inch mill and overlay from curb to curb and a minimum of 25 feet in each direction of the cut. The applicant is also responsible for any damage that occurs in the public right-of-way. If any public street or sidewalks need to be closed during the construction, the applicant must contact DPW in advance for approval. On May 20th, 2022, and a letter explaining the nature of the application and advising of the scheduled public hearings before the City of Laurel Planning Commission and Board of Appeals was sent by certified mail to all contiguous property owners. 2 read receipts were received. A memorandum from the City of Laurel Planning Commission to the Board of Appeals dated June 15th, 2022 reads as follows. At the regular meeting of the City of Laurel Planning Commission held on June 14th, 2022, the following action was taken on the subject zoning application. The commission, on motion by Mr. Welford, seconded by Ms. Bonner, and carried on a roll call vote of all members present, voted to recommend approval of special exception number 930 with the following conditions listed in the technical staff report to the Board of Appeals. Number 1, the applicant shall obtain all City of Laurel building, use and occupancy, and sign permits. The applicant is required to obtain an animal holding facility license from Prince George's County Animal Service Division prior to operation of the use. And lastly, the applicant shall comply with all federal, state, and local laws and regulations for the protection and use of the property. The file contains a certificate of publication verifying that this application and public hearing was advertised in the June 16th, 2022 issue of the Prince George's Post. The file contains an affidavit signed by the applicant attesting that a zoning sign has been placed on the subject property, has remained, and shall remain until a decision is reached by the City of Laurel Board of Appeals. That concludes the reading of the file.
Thank you, Mr. Mitchum. Board members, I'll open it up to any questions or comments you may have. We'll go around. We'll start with Ms. Collins.
I don't have any questions. I read it and I have no questions.
Thank you. Ms. Les?
No, I've read through it and I don't have any questions.
Thank you. Ms. Snyder?
I have questions.
Please.
Okay, my first question is, does the county have any regulations that people have to be there during the hours that these dogs are being boarded? That's my first question.
Yes, thank you for your question. Again, this is Joshua Mitchell, VCD staff. So we spoke with the Animal Control Division of PG County, and they said that Officer Cook of the division, and he stated that there are no known restrictions or regulations for having someone present at the facility. Typically what happens is during the inspection prior to the issuance of the license, they agree on a time. And he said typically it would be no more than 8 hours at a time, unsupervised. But the applicant has also reached out to me saying that they changed their plans and that they will be having somebody present, just kind of switching off. So
what does that mean? They'll be having somebody present?
Present at the facility overnight.
Okay, so how many dogs are going to be in there?
I'm trying to see if the applicant is on the line.
I
do not
am.
see-
I
Oh, you are?
am.
Okay.
I am.
All right.
Hi, this is Vanessa Oti from Paw Perfect. The maximum number of dogs depends on the size of dogs. If I have big dogs, it would be about 5 dogs. If it's small dogs, it could be 6 or 7 dogs. The dogs are going to be in what we would consider a crate, but they're called playpens, an average size 10 by 10 or 12 by 12.
Okay, because when I was looking at the plans, I'm
Yes,
not
ma'am.
sure what I'm looking at the proposed use floor plan, and for the boarding, I was under the impression that I was counting these squares on how many cages that there would be, and there looks like it's like 10 on each side.
So I put that in as an illustration. Those cages are not staying there because it operates as a dog daycare. Those cages gets removed each morning because it's a free roaming dog daycare with larger dogs separated off. So I indicated how the setup would be as a illustration. The cages are not even that close. That
Well,
was more for an
I
illustration.
suggest when it's coming before us, you should have the final plan here.
Because it's something removable, ma'am, it was very difficult to actually, maybe I should have put that the cages are removable because they're not going to be there during the day. Those are going to be folded up and tucked away. So they are not going to be 10 dogs together on each side, no. And for boarding, I'm not anticipating getting 10 dogs. It's not that type of facility. It's a facility where I have a couple of dogs during the night, and then during the day, they run openly. So it was a little difficult for me to illustrate the actual that they're going to be moved. It
Well,
was
where on
just-
the plan is the person going to stay there during the night?
There's an office to the front, ma'am, as you walk into the door to the left, where there's a table, chairs, refrigerator, and a chair, a couch. There's a
Okay.
front office, yes, ma'am. And the
Okay,
person who's going to
so,
stay is me.
How long will the dogs be confined during that time without getting out of their cages?
So the dogs have a schedule when the owner drops them off. They would advise me on what time was the last time the dog was got out, has gone for a walk. So most times a dog will go in the evening, and then I will take the dog out around 9 or 10 o'clock to make sure. And then
And
put
where
the
are you
dog back.
taking the dog?
I'm going to take the dog within the facility, ma'am, since that facility is set up with dog receptacles and poo bags throughout. It's a very dog friendly complex. That was one of the things that I indicated on the proposal that I set forth to the city of Laurel.
So they're not going outside to go to the bathroom?
Yes, they are going to go outside if need be.
Well,
But
in 8 hours, I'm sure there's a need that they'll have to do that, but I don't know where you're gonna take them.
Okay, so 595 Main Street, 133, set up on the ground level. So I'm going to walk the dog throughout the complex if he needs to go, if his poor parent did not take him before. And I'm going to have them use the bathroom, and I'm going to pick it up in the poop bags and drop it off in the receptacle or in the trash that's provided. So prior to opening, that was one of the things I wanted to check to see if it was an area where I'm able to walk a dog. And if that dog uses the bathroom, that they have receptacles throughout. It had to be dog friendly. And this was confirmed to me by the management of this property, that there are receptacles throughout to dispose of.
Okay. And is that what you do during the day when the dogs are there?
Yes, during the day, I would walk the dog, yes. Now, there are some parents who do not want the dogs walked. Like, they would tell me that they would leave their dogs when they go to work for 10 hours sometimes. And when they get home, me personally, I prefer to take the dog out just as a preference, because that's a pretty long time. They would
Right.
take the dog out at 7 or 8 o'clock, and they won't be home until like 6:30. And that's when the dog is trained to go again.
Okay. Okay, well, as long as you're saying that, I just had a problem with the dogs being left alone that long,
Right.
and how many, that it looked like we're gonna be there,
Right.
but.
I
Okay.
understand. I tried to address all the concerns that came up at the last meeting. This is my business and my baby. And if that concern was the dog being there, then I made that decision that if I have a boarding dog, that I would be there.
Good. Okay. All right, thank you.
Thank you, ma'am.
Thank you,
How many
Ms. Snyder.
employees do you anticipate having?
I'm sorry, ma'am.
How many employees do you anticipate hiring?
So, ma'am, it has been far and few between since I've opened this daycare. Right now it's me. But if things pick up, I'm going to have 2 walkers and 1 additional staff for when I leave, someone else is there.
Okay,
So total, I should say 4.
okay. It seems like a lot with just one person. So hopefully
Right,
we
but
can
I
get some
haven't
additional
had a
staff.
lot of business yet, because most of the times when I say daycare, the number 1 question I get is boarding.
Mhm.
So the business hasn't really picked up. So I've gotten, few dogs in between to watch for a couple of hours.
Okay, thank you.
Thank you, ma'am.
Thank you, Ms. Collins, Ms. Snyder. I do have a couple of questions also. With your business being a startup at this point, what's the maximum number of dogs that you would board overnight?
I want to say that depends on the size. If they're big dogs, the maximum I'll board for the night is 5. Because, I want to leave space in the middle of the place is pretty large, 5. If it's small dogs, I could probably board about 6 or 7 dogs.
So your operation would be a mixture of daycare and
Right.
overnight boarding.
Yes.
So how do you distinguish between the two in the sense of occupancy? That is,
So I'm
you
using
follow
the
what I'm
app. Yes, I know exactly what you're asking. So I'm using the app, this app called Ginger. So once the pet parent books there, it goes on my calendar. If I have a dog that's staying 5 days, that means that's 5 days considered day and night. So then I wouldn't exert the number of applicants. Then I would block off that I'm no longer able to take dogs, because the dogs that are there are going to be in the day, they're going to be in the night also. And it is considered a full day and night. So that's how I'm going to work it. So if I have 6, 7 dogs boarding during the night, then in the day, I can probably, because it's a free roaming, I can take 3 more little dogs if they're little dogs. But other than that, I won't be able to take, because it constitutes the same thing, day and night. So the calendar will be blocked off. And then when a pet parent goes onto the app, they will not be able to be book that spot because it would be blocked off as being full.
So your maximum number at any given
be
time could
10.
be 10,
Yeah.
right, depending on size.
Yes.
Okay. My next question is directed to the city. Is there any policy that the city has for monitoring, compliance in this kind of an operation?
Thank you for your question. This is Joshua Mitchum, ECD staff again. So for this kind of operation, if there are a number of noise complaints or if there is reason to show that this business is not being compliant in the conditions set forth in the technical staff report, we would be able to, revoke the use and occupancy for this business. So that's how we would monitor if, this business is not being compliant with the rules set forth, whether that would be any kind of sanitary or any kind of noise complaints, anything like that. We're able to tie it to, this business in the event that it's not being held to the standards that it, was set at this meeting.
Well, I got what you're saying, Mr. Mitchum, but my question is more, how would you know that unless someone's complaining? Or is there a schedule that, say, animal control or some other department in the city would periodically just go in to do health and safety checks, just to make sure that, the rubber mats where the dogs are allowed to relieve themselves is actually being used? These aren't necessarily things that perhaps somebody would complain about, like noise, but just to make sure that the operator of the business is complying with what has been approved and is operating within the scope of what's safe and humane for the animals.
Are there apartments on the second floor?
No.
Well, then who's gonna complain because there
Right.
won't be anybody there?
Also, another thing is per this license that she would be getting from PG County, she would be required to renew the license periodically as well. So before the issuance of this license, just off the bat, she will have to get her facility inspected by PG County. And then to answer your question as well, I can speak with the city's animal control division and see if we can set something up potentially. So that's something I can look into as well.
I
What time
think
does the
that-
animal control get off work?
I'm sorry, can you repeat that?
What time does the animal control people get off work?
I'm not sure. I'd have to get back to you on that.
I would say 5 o'clock.
So just to interject on that, this business will be no exception to, let's say, a PetSmart that would have an compliance with the question that you asked, even with animal control getting off at 5 o'clock. There's no way that, animal control goes to PetSmart or Petco, any other pet store, or just drops in. So this business is no different. But to answer your question a little more in depth, I currently hold a high-level clearance, and I tend to follow rules really well. So I don't think I would be doing anything to jeopardize my clearance with breaking any rules for what I'm approved for. So that's on my end. But with other pet stores, there is no way to measure that.
And that's exactly where I'm going as far as addressing this to the city. It's not singling necessarily your business out, but businesses like yours. While you may be a rule follower, there may be someone else who establishes the same kind of business.
Right.
Without any kind of, in my opinion anyway, any kind of checks. We do it with apartment rentals. We do it with a number of other things. I just think in this kind of situation, for the sake of being humane to the animals that are there, periodic inspections of the facility should be a requirement. So I'm asking staff to take something like that into consideration as not a rule for this business specifically, but as a rule in general, maybe something introduced to the council so that there are periodic inspections of any facility that houses animals of any type, that periodically there are welfare checks, sanitary checks, etc. Again, not directing this solely at you, but I think that should be something that's taken under consideration by the city.
Yes, yeah, we can definitely start a conversation with the council and the city administration and looking into how we can best address your concerns.
And Mr. Chairman, also, this is a business that is not located in a mall like PetSmart. This is located in a residential committee in the community in the historic district.
But it's actually so Patuxent Place is a mixed use commercial facility. So
I
it
know
is,
that, but there's
it's not
apartments
exactly,
up there. There's people living across the street.
yes, and even with when she initially submitted her application, we did take all these things into account. And again, she does have the permission of the property owner, who is well aware of everything that Ms. OT is going to be doing in this business. And we've come to see that it wouldn't be an undue burden or nuisance to the existing Patuxent Place community.
Mr. Mitchum, and again, this is just trying to cover all bases.
Mm-hmm.
Is that permission from the property owner in writing?
Yes, sir.
Okay, so it's part of the file that the property owner is well aware of the type of operation that is taking place at his or her property, has sufficient details that he or she is satisfied that his property, her property, is also above any liability that could occur.
Yes, sir. Actually, the property owner was in attendance of the planning commission meeting as well, so he was present for that.
Okay, all right. Okay. Any other questions or comments from the committee? If not, I will entertain a motion.
I'll make a motion that we approve special exception application number 930, resolution number 22-07-BOA 595 Main Street. Based on the comments that she made about the care of the dogs in the evening and that type of thing. So I guess this will be kind of a learning process for us, but I would make a motion that we pass it as presented.
Thank you, Ms. Collins. Is there a second?
I'll second.
Thank you, Ms. Les. Any discussion? Hearing none, I will just add again for staff to follow up with a recommendation to the mayor and city council on an overall ordinance or regulation for operations such as this in the future. This particular one, while it may be among the first, it certainly will not be the only one. I have 2 dogs, and one of the things that my wife has commented to me is that when we travel, we need to find a place to board them.
Please bring them, Mr. Smalls. They will love you. Please bring them.
My dogs are not people friendly.
Really?
Believe me, they aren't.
So then
But
I'll just
nonetheless-
watch your two dogs at night and no one's else. Please bring them.
Thank you. Ms. Quillen, would you please call the roll?
Ms. Collins,
Yes.
Les,
Yes,
Ms. Snyder,
I vote yes with reservations, and I'm hoping that staff will follow through and check out the business during the evening hours. And I just want to tell the applicant that I live a block away. I have a small dog. We like to travel, so I hope it all turns out.
Miss Snyder, please bring your dog too. I love dogs and I definitely would treat them like my own.
That's good to know. Thank you, ma'am.
Thank you.
Chairman Smalls,
I vote yes, and I echo the feeling of my colleagues on the committee. Certainly to staff, that some monitoring of such establishments should take place. And we wish you the best of luck.
Yeah.
Thank you very much, Mr. Smalls.
motion
Thank you.
carries.
Thank you.
Thank you.
That staff took care of both the application and the resolution, right? Or do we have?
Yes, sir.
Actually, we have a number 4. Agenda item 4 is the appeals application number 928, resolution number 22-05, BOA for 425 Prince George Street, filed by Michael Sciscenti. I hope I'm pronouncing that correctly. The applicant is requesting that the City of Laurel Department of Fire Marshal and Permit Services not enforce section 18-82.17 IRC-18 Part 2, Chapter 3, Section R311, means of egress, R311.1.1.1, means of egress of the Laurel City Code for the renovation project relating to City of Laurel permit number 20220207. Okay. Staff? Who's presenting?
Yes, good evening. This is Danny, Danny Selby, the Director of the Department of Fire Marshal Permit Services. You
Good
have
evening.
to forgive me. My camera is not working at this time. But I'm going to go ahead and get started.
Please.
Requested action. Waiver of the Laurel City Code requirements for egress stairs to exterior grade and to allow the 2 as-built egress points in the basement to be sufficient for finishing the basement at 425 Prince George Street. Some of the background information: on August 7th, 2021, a building permit application, permit number 2022-0207, was submitted to the City of the Laurel Department of Fire Marshal and Permit Services for a residential addition to the property located at 425 Prince George Street, Laurel, Maryland 20707. On September 17th, 2021, permit number 2022-0207 was issued by Fire Marshal Permit Services to the applicant. During an inspection on March 11th, 2022, Mr. Clifton Steed, building inspector, noted that the applicant was planning to finish the existing basement and expand the basement area as part of the addition. Mr. Steed informed the applicant that if he continued with adding the extra space in the basement addition, it would not meet Laurel City Code Section 18-82.17 for an egress door leading directly to the exterior grade. The applicant noted that the basement addition was planned with 2 exits, one via interior stairs and an egress window with a well and ladder in one of the basement rooms. Mr. Steed informed the applicant that the city had a local amendment to the International Residential Building Code regarding basement improvements that required a basement or cellar exit leading directly to the outside grade. The specific Laurel City Code section is below, which is the City Code Section 18-82.17, IRC 18, Part 2, Chapter 3, Section R311, Means of Egress, Section R311-1-1, Means of Egress. IRC Section R311.1.1 is added to read as follows. Means of egress. 1 and 2 family dwellings that undergo basement improvements for which a building permit is required shall have a minimum of 2 exits. All basements and cellars, when provided in 1 and 2 family dwellings, must have a basement or cellar exit door leading directly to the outside grade. All habitable attic spaces shall have an emergency egress window. Ordinance number 1952 2-24-20. On March 15th, 2022, Mr. Sciscenti sent an email to the Department of Fire Marshal Permit Services requesting a waiver of the Laurel City Code requirements for egress directly to the exterior grade and to allow the 2 as-built egress points in the basement to be sufficient for finishing the basement. Mr. Sciscenti noted in the request that construction had progressed to the stage that the addition time and major costs associated with meeting the requirements would place a significant burden on him and the project. On Friday, March 18th, 2022, the applicant was verbally informed during a telephone call with myself and Mr. Steed that FMPS would not support the request to waive City Code Section 18-82.17, IRC-18, Part 2, Chapter 3, Section R311, Means of Egress, R311 1.1, Means of Egress as requested. Fire Marshal and Permit Services staff and Mr. Sciscenti agreed that the basement matter would not prevent passing the final inspection for the addition if the basement remained unfinished. On April 20th, 2022, Mr. Sciscenti filed appeal application number 928 with the Department of Economic and Community Development, appealing the decision of the Department of the Fire Marshal and Permit Services to deny the applicant's request to waive Laurel City Code Section 18-82.17. The analysis, the Laurel City Code allows for appeals from the Department of the Fire Marshal Permit Services decisions as stated below. City Code Section 1820, appeals from the Department of the Fire Marshal and Permit Services decisions. A, grounds of appeal. Any person aggrieved by a desirous of challenging a decision of FMPS authority in connection with the interpretation, application, or modification of any provision of the Laurel City Code, Chapter 18, may appeal such decision to the City of Laurel Boards of Appeal and subsequently to the Circuit Court of Prince George's County, provided that the licenses first exhaust all of City Laurel administration avenues contained in this section. The true intent of the code or the rules legally adopted thereunder have been incorrectly interpreted, or the provisions of the code do not fully apply, or an equally good or better form of construction can be used. Procedures for taking an appeal. An appeal shall be filed with the City of Laurel Board of Appeals within 7 calendar days from the date of the final Fire Marshal and Permit Services decision being appealed. The appeal shall be in writing and shall contain a detailed statement of the reasons in support of such appeal. The applicant's original request was for the Department of Fire Marshal Permit Services to waive the Laurel City Code agreement, which was denied, and the applicant in turn filed appeal application number 928, again requesting a waiver of the Laurel City Code requirement. The appeal application does not state any of the 3 possible grounds for filing an appeal, nor does it contain a detailed statement of the reasons in support of such an appeal. The recommendation, staff recommends that the City of Laurel Board of Appeals deny appeal application number 928 because waiver of the Laurel City Code section requirement is not allowed for the Laurel City Code, and the application failed to meet any of the required grounds for the appeal as outlined in Laurel City Code section 1820. And that's all I have.
Mr. Smalls, you're muted.
Again, I'll start over again. Thank you, Mr. Selby. Ms. Pullen, is there anyone that you have signed up to speak?
I do have two speakers tonight. The first one would be Matthew James Sullivan.
Mr. Sullivan, are you available? Going
Who's
once.
the next one?
Okay.
Adrian Simmons.
Yes, hi, Adrian Simmons. Pleasure to be before the board. Thank you for taking time to listen to the thoughts. So, speaking on the special exception application here, number 928, it was good to have that rundown from the FPMS. Certainly, as a homeowner and as a citizen in the city, it's good to know that these types of things are being evaluated and different provisions are made for the safety. My understanding is that the homeowner, went through the proper application process and submitting plans and got the full approval for the plans that didn't change subsequently. And, obviously was 60-80% through construction, and this came up months later for them. And so it really was a mistake by those, who were approving that to know that this particular code section hadn't been met in the plans as originally submitted. So, just thinking as a homeowner, and this is in the city too, to say, presuming that, the city isn't going to bear the cost of the mistake, it seems a little unjust to ask the homeowner citizen to shift that cost over onto them. So, and especially in light of the fact that the plans as they exist, do provide for adequate egress that does meet the equally good construction standard. Even if that particular language wasn't used in the original appeal application, it doesn't seem to me that it should be denied just because of that particular language use, because it does exist there through the windows and the well. So to my mind, it seems like a tailor-made situation for an exception waiver, and certainly that would be my encouragement for the board to take under consideration. And that's all I have to say.
Thank you, Mr. Simmons. Ms. Quillen, is there anyone else signed up to speak?
I do not have anybody else signed up to speak.
Is there anyone else who would like to speak?
Mr. Chairman?
Yes.
Chairman
Mr.
Smalls?
Twelve?
Yes, good evening, Mr. Chairman, members of the
evening.
board. I'd like to ask Mr. Simmons if he is here in a representative capacity for the applicant, Mr. Sciscenti.
Good question. Yeah, I am a friend of Mr. Sciscenti, so part of the neighborhood here, just part of the community. So I'm not in a legal representative capacity, if that's what your question is, just more as a friend of the community.
Thank you.
Mm-hmm.
Yeah, I would like to speak at the appropriate time. I'm not sure when that is, so I'll wait.
How's the time, sir? Yes.
Thank you. I really appreciate the board's time and consideration, and thanks to the FPMS for preparing the packet, and Adrian, thank you for sharing your thoughts there. I'd like to provide a brief overview that includes a little bit of context that gets lost in the application, just because it was in the more full email that I attached to the application. But I just want to go over that briefly, if you will permit me to. We submitted the addition permit in August of last year, as was mentioned. The plans in the packet included a finished basement, which is on the screen right now. And just as a note, this was a 25-page plan. We had engaged an architect who specialized in historic properties, historic architecture. So we were working hard to meet the requirements of both the city and the Historic District Commission. And 9 of the 25 pages, so over a third of the packet, highlighted the basement being finished in some form or another. It wasn't always as obvious as this page where there's a bed in the basement, but many of them had that. So over a third had notes like that. And then they were stamped in September of last year. I assume this meant the plans met code, including the basement, because if it hadn't, we of course would have remedied that. And I confirmed in that conversation that was referenced, and it notes it in the email that I sent summarizing the discussion in March. The Fire Marshal Permit Service confirmed that that wasn't an unreasonable assumption, that if they issue a permit, that it meets codes. So we proceeded to build as planned. In the time from September when the permit was issued until March, the 6th inspection, there were 5 inspections. Presumably, I assume, I don't know this for sure, the plans got looked at again. And in all of those 5 inspections, this was never caught. My contractor indicated when this was caught that there's the egress, 2 egress points didn't meet code, that it would cost at least $15,000 because I know it was mentioned, but the basement was done, framing was done. So we were ready to start putting up drywall. That's why this inspection occurred. If I recall, the right term is a close-in inspection or framing inspection and then the close-in. So everything was done. The basement was built and poured. And if we had been notified, if this had been raised prior to issuing the permit, or even a month or 2 after, before the basement was poured, we would have happily added the stairs, or alternatively switched to a crawl space, since we're not really clear on what the point of spending the additional cost of pouring a basement would be if it cannot eventually be used as extra space. So unfortunately, I wasn't given this opportunity. And so we relied on the permit being issued to mean that our plans met the code and we built. And so for these reasons, I'm respectfully asking the Board of Appeals to honor the stamped plans and issue permit from September of last year, and let those 2 egress points that we have to be sufficient, which I admit was not the exact wording of equally good, but I think sufficient is probably a synonym for equally good, to meet the code, which I would point out that prior to the ordinance in 2020, my understanding is that would have met the code. And so I respectfully ask for your consideration today in granting us this waiver. Thank you.
Thank you, Mr. Sciscenti. I'll now go around to the board members. Any questions or comments, starting with Ms. Snyder?
Thank you, Mr. Small. So, Mr. Sciscenti, I want to make sure I understand this correctly. So you're saying that the inspectors were there over 5 times and never told you anything about this basement entrance. Is that correct?
Yes, that's correct.
And when did they tell you about it?
At the 6th inspection, 6 months after issuing the permit, March of 2022.
Did they find other things wrong when they were there before?
I believe there were a few minor things. I was with COVID. I'm from this area originally, but I was remote. I bought the house remote, so I only came down twice. Unfortunately, I wasn't here for any of the inspections until the one we had a couple of weeks ago.
Maybe that should have. Okay. In that basement, is there a window?
Yes, there is there's an egress window with a ladder to get out. It's shown there. It's that in the center and on the right one there too. Actually, in all 3, it's that well there on the right side, the rectangle that sticks out from the larger the room with the bedroom.
Are there sprinklers in the house?
No, there are not sprinklers. We were careful to maintain under 50%, and then we had a discussion because in the month prior, so 5 months after issuing the permit, we were we were told we would need sprinklers, but even though they'd issued the permit under the assumption we would not. And I have the emails documenting from the previous fire marshal, we had agreement. He said that his calculation, we were $2,000 over the threshold for cost, which incidentally, if we're not finishing the basement, would no longer probably be the case. But they were, because they made a mistake and issued the permit and let us proceed to build without the sprinkler, they would waive it for the $2,000 over cost, even though we
I'm
didn't hit
sorry,
the
who
square.
told you that they would waive it?
The prior fire marshal, I can pull up the email. I'm forgetting his name. Was it Allen?
Steve
Fire
Allen.
Marshal. Steve Allen. Yes.
Ugh. Well, my first comment was before I heard the remarks here was, why are we even seeing this since the city had already denied it? I couldn't understand why we were even talking about this. But now that I've heard the testimony, I see there is a reason why. So I'm going to see what everybody else has to say.
Thank you, Ms. Snyder. Ms. Les,
No, no questions.
Ms. Collins.
I'm just a little baffled by this situation. So the egress that you have now, the window with the ladder, is the ladder down the whole time so that, God forbid, there should be a fire and they can't go upstairs? They can get to that ladder, and suppose they're handicapped or something. I mean, are they able to get out?
It's a fixed ladder. It's drilled into the it's attached to the concrete there, or the cinder blocks. Sorry, definitely cinder blocks.
What about the size of the window?
It's a casement window. I'd have to go measure it. I don't remember off the top of my head, but it's to code. For my understanding, it was to code for egress windows. But yes, someone were handicapped, they wouldn't. There's about 10 to 12 steps into our basement, so you wouldn't be in our basement if you were handicapped, unfortunately.
Is there anybody that is going to be living down in the basement? One of the kids? Is their bedroom going to be down there?
No, not at this point. The main purpose of the basement at this point was that center room there was going to be a playroom, and that was a guest bedroom, at least for now, and which we don't have guests very often, but yeah, that was the purpose.
So it's only your guests that we're worried about, huh?
I mean, if it were finished, right? I mean, at this point,
Right.
yeah.
Mr. Smalls, I'm wondering why they're, on a matter like this, why one of the inspectors isn't on this.
Mr. Selby
meeting.
is here. He's the one who made the presentation.
And Mr. Steed's he seems to be on Zoom. At least I see his name. He was the inspector.
Yeah. I have a question for Mr. Selby and or Mr. Taub, and that is, in looking at the drawing, first of all, and what I'll just call the bump out or window well, that's part of this discussion. And what is stated here in section R-311.1.1, where it says in part, must have a basement or cellar exit door leading directly to the outside grade. If a ladder is required here, does that meet the definition of that statement I just read?
Mr. Chairman, I would suggest to you that the language there is pretty clear that it says a basement or cellar exit door. A door is not a window. A window is a very distinct type of opening in the house that is not in any way equivalent to a door. And I think it's plain language of that statute to me is very clear.
Well, I'd actually like to add something to that because we have our architect was pretty creative, and so we said, okay, we'll just change it to a door. That was rejected because it doesn't meet code. And so just for this is what we received, so everyone understands. You start with 311.1, but then you need to look at 311.2, what an egress door is. And then you need to look at 311.3.1 for floor elevation required at the egress door. And then you need to read down to 311.7 to understand stairways. So then we also look at a spiral stairway, which apparently would meet code, but there's unfortunately not enough room there without additional excavation. So it's not, unfortunately, it's not that simple because we thought okay, we can just turn the window into a door. And we offered that, and unfortunately that wouldn't meet code.
Mr. Chairman, may I ask the applicant a question?
Absolutely.
Mr. Sciscenti, you indicate you have an architect here that prepared these plans. I'm assuming the architect is familiar with code provisions. So while it sounds like he was trying to get creative, I guess the question is why he did not pick up on that issue to begin with and avoid the necessity for having to be creative and work around this issue in some manner.
Sure, I think I think there's a couple. He missed the full what I just walked you through in the code. It was potentially a mistake. He's also he's now a full-time professor of architecture in historic design and modern urban. I don't know the exact name, but modern urban historic design. So it could be that this is the 2018 code and he just missed it because it wasn't, he wasn't fresh. But that being said, my understanding is that that's what the permit process is for, is to catch these things. But yeah, I mean, we were very clear. We didn't hide the fact that there was a window egress down there. As you see, the windows there too. But yeah, it wasn't. It wasn't caught that it needed to be stairs to grade now in Laurel.
And please understand, I'm not in any way suggesting that this was intended to be that you were trying to avoid, anyone understanding this is the way that the construction was intended to be. I'm not suggesting that at all. My only suggestion would be that it is, among other things, the responsibility of the architect to design the addition to code requirements. And there actually is case law in the state of Maryland that indicates that that while there may have been a good faith effort to do so, if the permit was not issued to code, it's not a valid permit. And you have no vested right at that point in time. So I'm sympathetic to the facts, Mr. Sciscenti, I really am. But the fact is that when we're dealing with issues such as this, that we're with, especially with life safety issues, the code is obviously critical, and the fact that it may not have been picked up earlier does not absolve, first of all, the architect for not designing it to code to begin with, and the fact is that if it does not meet code, and if the board does not find that you have found a determination, an equally good or better form of construction here, then I think there's a real question as to whether or not that remains valid. I think that there has to be, the code must have primacy, and in all situations you have to meet code. So I think there's a question as to why it wasn't designed to code to begin with, and that's really where the issue began. Frankly, had that been done, we wouldn't be here tonight. I'm not suggesting, again, people make mistakes, that happens, but in this situation, I think the question is whether or not the board should be granting the appeal to the application here with regard to this particular condition of particular provision, excuse me, of the code?
Yeah, I think I would simply point out that this was we undertook a large project. I think it's assumed there's going to be mistakes made by by the architect and others. This particular mistake, though, was compounded because we didn't if this didn't get enforced until 6 months after, when it was visibly there. And I would point out that this provision, there are certainly, from a life safety standpoint, plenty of basements in the city of Laurel built prior to when this ordinance started to be enforced, that probably had very similar egress, if not worse. So while I understand the concern with the current code, I do think, like, from an equally good or sufficient perspective, like this meets or exceeds probably a significant number of finished basements in the city of Laurel, I would imagine.
Let me just interject here just a second. The comment that was just made by the city attorney was one of the first thoughts that came into my mind, and that is, I would think it would be incumbent upon the applicant and the architect, et cetera, to be thoroughly familiar with what the requirements of the code is, whether it's life safety, whether it's construction, any number of things as the building is being designed, developed, or remodeled. I will also say that this code, or at least some parts of it, was something that I was involved in as a councilman and voted positively in support of this kind of language being introduced and being enforced. So with that said, for me, I stand firmly behind the decision that was recommended by staff. And I'll ask the commission if there are no other comments or questions for a motion. I say commission, but the committee. Either we will recommend denial of the application, or we recommend that we accept Mr. Sciscenti's request for an appeal.
And what if you don't have either one?
I'll turn
I
to
don't
our
think
attorney.
we have enough information. I feel like we haven't heard anything from the inspector except to read the city code, which we could read that ourselves.
Mr. Selby, you're still on?
Yes, sir.
Were you the inspector or one of the inspectors for this project?
No, sir. Mr.
Okay.
Steed was.
Okay, and he's no longer with the city, is that correct?
No, he is the
Yeah, he's moved to another position.
he's a building inspector, but Steve Allen, the other fire marshal, he was the one that retired.
Well, I'll ask the board, what's your pleasure? Do you want to, table this while we gather additional information? Mr. Taub, I'll look to you for what's the proper course of action, but it seems just from a lack of response from the committee that there may be the need for additional information and discussion.
Mr. Chairman, I believe the board certainly could table this if they wish to obtain additional information. That's the board's prerogative. I think it would be helpful if the board could indicate the specific information that they're requesting so that it's very clear to the staff and to the other board members exactly what information is being sought for this purpose that the board believes would be helpful to it in making its decision.
Unknown caller.
Ms. Snyder?
I'd like to present a vote that we table this item until we get more information and hopefully meet in person.
And as Mr. Taub asked, what specific information would you deem helpful for the board to review regarding this application?
Well, I suggest that we each get that together. I don't think we can just rattle off right now. At least I can't. I'd like to read all of this information again. But I'd like to see what the other members have to say.
Ms. Collins?
I'm very torn. I would like to, if possible, meet with Steve Allen and discuss.
He retired, Marla.
I know, but I mean, still, maybe we could discuss with him the process of getting this approved. Something's missing.
There's a disconnect here.
Yes.
Yes. And I feel for the homeowner, but we've got to be very strong on the safety of people in their homes in case of fire, trying to get out. Especially if you have a small child. I can't see a small child climbing up a ladder and getting out. I just think there needs to be a little bit more discussion on this.
One of the things, committee members, that I want to stress is that we have a responsibility of looking at the ordinance, the regulations, and to a degree being sympathetic to a particular applicant and not giving full attention to what the law says is also doing a disservice, in my opinion. So I am certainly asking us to examine, if we want to table this, to examine very closely what the law says and to take that into consideration. And not casting any disparaging words on Mr. Sciscenti at all. But we have to view every application that comes before us based on the law and the rules that are in front of us.
Well, I think based on the law,
Sorry.
I think based on the laws and rules in front of us, we would have to deny it.
My question is why the inspectors were down there 5 times and, never had a problem with it.
Let's take a vote. There is a motion to table. Mr. Taub, in response to your question, I'll just kind of step out and say perhaps one of the things that we would like to have a look at would be any files that the inspector, whether Mr. Allen or anyone else, put together on this particular project. Presuming with all of the visits that were made to that site, to that project, there are notes, there are a number of matters of record, I would presume that would be in a file for it. So if I can speak for my colleagues here on the board, perhaps having a look at whatever the inspectors put in the file may be helpful in us making some decisions on how to move forward.
And also, if there are other options, what options the applicant, if there's more than one option to correct this.
If I may also add, we do have the building inspector that caught the issue on this Zoom call, Mr. Cliff Steed. So if you
Oh,
have
he
any
never
questions-
spoke up.
Oh,
Yeah.
yeah. I'm
He's
sorry.
here.
I've been having problems with my mic. Yeah, okay. Is it working now?
We
Yes,
hear you.
hear you.
Okay, yes. Yes, in my notes here, I performed a footing inspection on November 1st of 2021. On November 5th of 2021, I did the wall foundation. And on 11/18 of 2021, I did the anchor bolts on the wall foundation. The last inspection that was conducted was December 14th of 2021 with the slab in the addition basement. Until then, there was all the time, there was almost 3 months past on March 9th of 2022 is when I caught the code fraction, when I did the framing. There again, I based on that, kind of got threw off with the off guard with the window well, not thinking at the time about the second exit door that has to be from the basement. But that was just 3 inspections performed before of March 9th of 2022. But that's when I found it in the framing. Now we note when we stamp these drawings, if you notice on the second line, it says subject to field review and inspection. Unfortunately, I didn't catch it till I got to the framing issue, the framing inspection, but I was able to catch that at that time. Noted on the screen.
So the fact, if I'm understanding you, Mr. Steed, that that during this process, at any time during this process, any kind of a code violation can be discovered and addressed to the property owner, in this case, to the applicant. It
Yes.
doesn't have to follow any specific timetable. That is, doesn't have to be 6 months ago. It could be as as the process is moving forward. Is that a clear assessment of how that works?
Well, basically, we try to catch everything at the time of the inspection. Unfortunately, everybody's human, and we tend to steer off when you're looking at something suddenly, in the breast of the thing, and then being able to catch something later down the line is obvious.
I don't presume that's anything unusual either.
No, nothing unusual, but yeah, we just admit that catching it in the early stages based on when it was stamped and approved, never looked at it, could be being based on a city code, which is the local amendments. That this was addressed in. It was not, this really doesn't come up a lot. with this type of structure and a type of build, you know, on the addition. Because most of the additions are just crawl spaces, and then you have your first and possibly second floor.
Thank you, sir. Committee members. What's your pleasure?
Mr. Chairman, I believe there's a motion to table on the floor.
There is. With that motion, is there a second to table?
A second.
Okay, we have a motion and a second to table this matter while the Board of Appeals seeks supporting information from our city code enforcement building inspectors. Is that an accurate assessment of why we want to table?
Yes.
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 Okay. Ms. Quillen, will you please call the roll on the motion?
Ms. Snyder,
Yes.
Ms. Collins,
Yes.
Ms. Les,
Yes.
Chairman Smalls.
In support of my colleagues, I'll vote yes.
Motion carries.
So we are tabling this matter for a future meeting. Now, I have to presume that anything that may have been placed in effect regarding this project by the city still stands while this committee reviews any additional information. Is that a correct assessment? For example, if there was a stop work order or anything like that, I don't know that there was, but I don't know. I would have to presume that.
We've closed out the permit. So part of the agreement to appeal was to commit to not finish the basement during the appeal. And so we could get because I financed this part of this addition, so I needed to be able to close out with the bank, the permits. So we had a commitment. So the final inspection occurred a couple of weeks ago.
Okay, Mr. Taub, any comment?
No, I think as well as Mr. Sciscenti understands that basically everything should remain the status quo at this point. That there will be no filing of the permit, no ability to occupy the space until such time as the board makes its determination. I think that should be very clear. And I don't know if it's the practice of the board to send a letter with regard to the tabling of the motion, but if that can be done, then the letter should again emphasize that there can be no occupancy of the space until such time as the board makes its final determination and a final occupancy permit is issued.
I agree with that. What's the feeling of the board? Is that, you agree?
Yes.
Yeah. Yes.
So we'll ask staff to put together a letter that would be made available to Mr. Sciscenti as well as any other interested parties of the decision made here tonight by the Board of Appeals and when the appropriate time to announce the next meeting when this application will be before us, will be promulgated to everyone that has a need to know. Is that agreeable?
And
Yes.
just so I'm clear, as secretary to this board, you would like to see the copies of the inspections, any paperwork in the file regarding the project.
Yes, I think that the board, those documents should be made available to the board. My presumption would be, Ms. Quillen, that they be available somewhere in City Hall where members of the board can come and review them.
Okay.
I have no idea how large a file may be. I mean, so it could be, several pages rather than making copies or scanning and any of that. Just make the file available to us, I think. Let us know that it's there, and then we can take the time either together or individually to come in and review it to satisfy our any questions that we have.
Okay, I'll work with that department and get that ready for you guys.
Excellent. Thank you. Is there any other, Mr. Sciscenti? As
Yeah, I would
you've
just-
heard, we're tabling. You'll get a letter that spells out exactly what was decided here at this time. And of course, you'll be notified of the next Board of Appeals hearing to discuss this matter further once the members have had a chance to digest the record.
Appreciate the time, and just really encourage everybody. It appears this board has the ability, it's in your purview to say that what we've done, which was in the issued permit, was equally good construction. So I encourage you to take a look at that and consider it. And I know you have so far, and appreciate the time. Thank you.
Thank
Thank
you.
you.
Is there any other business that come before the Board of Appeals? Seeing none, meeting is adjourned. Thank you, Ms. Quillen, Mr. Taub, board members, staff. Thank you all. Enjoy the 4th of July holiday.
Thank you. You too.
Good night.
Thank you. Good night, all.
Good night.